Okay. Gave enough time to get some people back in here. There'll be more coming in, I'm sure. Yeah, I'm going to run, and you know what I might be doing. um, I might just keep replaying this and be live, but just keep replaying it. And then sometimes I might jump in and add some panels through the day here. Depending on who all comes in and whatever. So yeah, that's what I think I will be doing. So I'm going to share this again. Oh, come on.
And you probably also know that we are streaming now, and that is on a YouTube channel. If you don't know that,
And there we go.
To the court.
That's right from the judge's page.
I guess website, and you can get that channel if you don't have that already. So you don't want to be on a camera, you probably should leave. But generally, we can't see very well farther back in the courtroom. So just so you're aware of that. So today, we are addressing reconsideration of the order denying motion to dismiss the indictment. And that order is focused on the claim of inaccurate instructions to grand jury. Also coupled on that is the potential for permission for appeal for interlocutory order. So, and a stay of proceeding in the case. I think that's all the preliminary. Ms. Taylor.
Mr. Logston will be arguing, Your Honor.
Okay, Mr. Logston.
I'm gonna, I guess, be succinct since we argued almost the very same thing this morning. But in essence, what we're asking the court to do is to give us the court's blessing to take up the issue to the Idaho Supreme Court. I think the court has noted that it's certainly an interesting issue. The Idaho Supreme Court does have a rule that essentially lays out that this is to be done in very rare circumstances, important issues where people may disagree and that may make it more orderly in a particular case. Our argument is that for this case to exist, the indictment needs to be valid. If there's something wrong with the indictment, that's something that certainly should be addressed. We're also concerned about the fact that there is case law that says that if this case goes to trial, issues with the indictment may become essentially mooted by that and would never be answered. And there's relatively little in the way of case law in Idaho in the last 20, 30, 40 years. And so without permission to appeal, we may never get an answer on this. And certainly that's very important to Mr. Kohberger, because whether or not there's a valid indictment in this case is going to decide whether or not he sits here and whether or not a trial should occur, et cetera. One of the major issues is whether or not that's going to have an issue with the timeliness of this case.
One thing is we're
that's going to
be able to
the
see
next argument that comes after this one.
See them in action.
We believe if a trial is set out as far as we think it ought to be, that
I would think they'd be a little more spark, but whatever.
Disturb where we think a trial should occur in any case. And in any matter, this isn't our attempt to achieve some delay. This is our attempt to make sure that our client is getting due process at every step in this case, and that nothing is being left, no stone left unturned. Thank you, Judge.
Thank you, Mr. Longston. Mr. Nye?
Thank you, Your Honor. I want to start with the rule that was just referenced. It's Idaho Appellate Rule 12, and it governs interlocutory appeals. And the criteria in that rule set out two factors the court is supposed to consider. The first is whether or not there are substantial grounds for difference of opinion. And on this particular issue, as the court stated in its order, the standard of proof for grand juries in Idaho has been consistently probable cause for at least 3 decades. That doesn't sound like substantial grounds for a difference of opinion. And in fact, the defense conceded in their opening brief on this issue that, quote, the whole of modern jurisprudence on this issue is against this novel theory that they've raised. So they haven't met that first factor. The second one asks whether an immediate appeal may materially advance the orderly resolution of the litigation. And I have not yet seen in their briefing or heard in their argument any path forward for them in which winning this appeal materially advances this litigation. I think if we're all being honest with ourselves, a trial in this case is going to happen. And the question is when. And if we send this case up on appeal, even if the defendant wins, the law clearly allows for us to bring the case back. Even if the Idaho Supreme Court goes out on a limb and says, you're right, the standard of proof in a grand jury should be beyond a reasonable doubt, we could use a normal complaint and probable cause hearing in front of a judge. So it would be the same standard yet again, and we would go in a whole circle, basically resetting the case to be where we're at today. We need to get to a trial in this case. And that brings me to my final point. I'll also try and keep this short. There are secondary factors that the Idaho Supreme Court has looked to in addition to that rule, even when those first two factors
He
are met,
tries to say,
decide,
we
is
need to get
actually
this
the
to
case
trial.
that we
Yeah,
want
well,
to
they're
take
the
in
ones that have
interlocutory
been
appeals.
delaying
And my read of those
well,
secondary
both of them
factors
have,
is
but the
it's really
prosecution
asking, like,
more than
what
the
is the
defense, in my
effect of this
opinion.
appeal on the litigation and on the parties and those involved? And I would just like to point out to the courts, under the rules, this is Idaho Appellate Rule
Maybe if they would give
13F,
all the evidence
and it's talking about the stay upon permissive appeal. And it says in F sub 2 that the granting of a motion for permission to appeal under Rule 12 by the Supreme Court automatically stays the entire action or proceeding until the appeal is terminated. So at that point, there's no more discretion. It automatically this case hits the pause button. But more than that, Your Honor, it continues and says, and during that time, the district court or administrative agency shall have no power or authority over the action or proceeding. We're not just talking about a stay in the proceedings. We are talking about this court losing its power and authority over this case while the appeal makes its way through the appellate process. That is going to cause significant delay. As we're about to have an argument or a conversation at least about scheduling. And there is a lot that needs to be done before this trial happens. And this court will have no power to address those issues if this case is pending on appeal. Now, in full disclosure, there are some exceptions to that rule, but it's the exact same exceptions that apply to an appeal as of right after judgment. So it's things like you can change the sentence, you can sentence the defendant, you can change.
I get a kick out of is first the state pressures Kohlberger and team to drop his speedy trial, right? And now they're going, let's go for this summer, and now they're pushing to make it end faster. First, they pressured Kohlberger and them to drop that speedy trial, and now they're after a more speedy trial. because they know that the information is going in slow to the defense. They're getting like bits and pieces here and there, and they keep asking for more and more. I mean, how many times do they have to ask the discovery? They're on their they've already done, I think it's 12 times. So any more, it'll be the 13th, 14th, 15th, 16th. And there's plus there's 9,000 new tips. I thought that was huge. That is huge. That means the community does not believe. I don't think all those tips are against Kohlberger. I think there's tips coming in that pertain to Brian being innocent. And I'm hoping they get those tips too. You know what I'm saying? I hope that they get all the tips that are coming in. I don't trust this. I don't trust this prosecution, or I don't trust the LE. Not one bit.
Fail, things like that. But for discovery, we've had the genetic genealogy issue that's still out there. We're working and making progress on, but pause button on that. Pause button on discovery. Pause button on change of venue. Pause button on motions about experts and who can say what. It would significantly delay this litigation, which brings me to my final point, and that is I don't want to lose sight of the fact of the seriousness of this case. We are talking about a quadruple homicide under Idaho's law.
Like who's losing?
And not only are those who were killed victims, but every single one of their immediate family members is a victim. And in this state, in Idaho, our victims have a constitutional right to a timely resolution of the litigation. We are already quite a ways out. And the idea that we would hit the pause button and take power away from this court because there is a interesting issue for the Idaho Supreme Court to address is not
Well,
something.
I'm sorry,
that this
the
court
man
or any
has
court should tolerate.
a right to a fair trial.
It's time for a trial, Your
It's
Honor.
called.
Thank you.
Mr. Nye. Mr. Lawson? Reply?
Judge, once again, we believe this to be an important issue and one that is worth getting a glance, at least from a higher court, rather than being tucked away and forgotten in the maelstrom that is to come. As the state undoubtedly knows, trial won't put an end to this case. This case will go on for 28 years if they do actually achieve a conviction. So the idea that somehow we're running towards something and that's going to do anybody any good from their standpoint is, I think, false. What we're trying to do is make sure that the things that occur in this case are done correctly. And if you want to talk about how long things are going to take, get some stuff wrong and then see how long it all takes. We're asking that the court would give us permission to go and see if the Idaho Supreme Court would be willing to weigh in on this particular subject. Whether or not the case makes its way to trial at some point is, in our mind, just part of what the court has to look at, particularly in a case where the state's decided that it wants to try to kill someone. Thank
you. Excuse me. Well, first of all, this is a reconsideration of the order relating to dismissing the indictment, whether or not the standard for proof on a grand jury is probable cause or beyond reasonable doubt. I don't think we've done anything wrong about that. That decision was put out quite a while ago. It's rooted in well-settled law. And I think it was correct. Supreme Court, I guess, could turn that around, but that is doubtful in my opinion. We went through Idaho Constitution, statutes, case law, criminal laws, and really common sense. So I feel quite confident that that was a correct decision. So that established that it is well established that the standard of proof for indictment in the grand jury is probable cause, not beyond a reasonable doubt, which is the standard for trial. So putting that aside, now we get to this permission to appeal under Rule 12. So, excuse me, let me just get this in front of me. So the criteria for permission to appeal, this is in Rule 12 of the Idaho Appellate Rules. First of all, it's very, very rare in case law for such an appeal going to the Supreme Court. It does happen, but it is rare. And the court has established this criteria. And I'll just read this part of this. The issue needs to involve a controlling question of law as to which there is substantial grounds for difference of opinion. Again, in my opinion, and based in all the law in Idaho that I've found, is that there is not a difference of opinion about what the standard for the grand jury is. So the defense is making that argument. I respect that. I don't agree with that, but that's where this is. I don't see a difference of opinion throughout the state about what the standard is for grand jury determining an indictment. But this also has a second component. And this is something that Mr. Nye really focused on, is which an immediate appeal from the order may materially advance the orderly resolution of the litigation. And I'm very concerned about delay. And I think that if we send this to the Supreme Court, that it's going to add delay. Mr. Logston is correct. I mean, this is a complicated case. It could take a long time, longer than any of us want. But I think that would add additional delay. As I said, I'm already concerned about that. We're over a year. Could be another year. I'll just let you all know that. Now, even if the Supreme Court takes up this appeal, or I deny it, and I'm going to deny the permissive nature of this. If I deny it, the Supreme Court can still pick up the appeal. That's up to them. But they do look at what the district judge's opinion may have some bearing on that. I hope so. But they could still overturn the orders of this court denying the motions to dismiss the indictment. And they could dismiss the indictment. What would happen then? Okay, is this going to really materially advance the orderly resolution of the litigation? The state could just file it, refile it, as Mr. Nye said. So that's significantly more delay. So there's some other, actually, this is in a case law, Buttle versus Todd.
I think this judge is confused
Case,
on what to
1983.
do.
The court also considers other factors, including the impact of the immediate appeal upon the parties, the effect of the delay of proceedings in the district court pending the appeal, the likelihood or possibility of second appeal after judgment is finally entered by the district court, and the case workload of the appellate courts. But it finishes with an appeal must be exceptional, seeking of that appeal. Because the Supreme Court doesn't broaden the appeals, which may be taken as a matter of right under Rule 11. So, in my opinion, I do not find that the criteria is satisfied for a permissive appeal. There's no controlling question of law where there is substantial grounds for difference of opinion. The law is settled as far as I'm concerned, and there's no difference that I'm aware of. I also do not see how the appeal could advance the case. To the contrary, it would stall the process when we really need to move forward. So I'm denying the permission for appeal, obviously denying the motion to reconsider. And with that, I think we are ready to go to setting a trial, or at least a schedule order. So anything else about this issue before we go to that? Ms. Taylor?
No, Your Honor, thank you.
Mr. Thompson?
No, sir.
Do you want to go first, Mr. Thompson, about the state's position on scheduling?
Yes, sir. I'd be happy to. And to start, Mr. Lodson said something that I think needs to be addressed. He makes the allegation the state is trying to kill someone here, and frankly, I find that offensive. What the state is trying to do is to enforce the law that our legislature has put in place. It says, in cases such as this, with facts, a jury is entitled to decide not only guilt, but potential fulfillment. We are simply trying to fulfill our responsibilities under the law. To characterize it as the state is trying to kill someone, it's just simply appealing to raw emotion, and it has no place in this court. We would ask that that not be allowed any further. Now, as to the trial, Ms. Nyer already noted that we have a variety of competing interests here. We have certainly the defendant's right to a speedy trial, which he has waived at this point. There are also interests of the state itself, and I think even more importantly, the victims and the families of the victims in this case to a timely disposition of this case. Granted, this is a complicated case. It is a very serious case, and a lot of effort needs to rightly be put into it to make sure the case is handled correctly. At the same time, we need to also balance the need to move forward in a constructive, productive fashion. When the state filed our motion asking for a scheduling order and trial date, which was a little bit over a month ago, we proposed the summer of this year. And at that time, and at this time right now, we believe that we could be prepared for trial summer of this year. We realize defense has factors and considerations they want Your Honor to take into account, and certainly we want to afford them that opportunity. I will say though, that we touched on this in our motion, in our request for the scheduling order, that given the nature of this case, if we are going to try this case effectively with minimal unnecessary harm or disruption to our community, it should be done during the summertime. And I say that because right across the street there is Moscow High School, that shares parking all around the courthouse with everybody else who's going to have an interest in this case and being here. And we've already encountered the conflict between those interests. We can't sustain that for weeks and weeks on end. That's just not fair to the students. It's not fair to the school district. It's not fair to the media. It's not fair to anybody. The other factor is, as Your Honor knows, we have two universities, part of our community. And during the academic year, we have graduations. We have numerous sporting events and other university-related events that essentially consume every available hotel or motel room within miles. This case is going to involve bringing in people from out of state, numerous witnesses from out of state who will have to be put up in lodge. And we would submit that that's going to be unnecessarily complicated if trial occurs while the universities are in session. So those are the considerations that we have, Your Honor. As I said, we filed this last month. At that time, and as we stand here today, we believe that we could be ready for trial this summer. Thank you, sir.
Thank you, Mr. Thompson. Taylor?
Thank you. Your Honor, I received Mr. Thompson's motion for a scheduling order, and I had the opportunity to meet with him and talk with him and
I think what's being said though, and I think gonna be said here, is Ann Taylor doesn't want it. I mean, they waived their right. They were pressured to waive his right to a speedy trial. And we all seen that unfold. And so now they're trying to pressure him to go to a speedier trial, and they're not getting the information. They're not getting the discovery that they are deserved. So of course it's going to take more time. The thing is, does the judge recognize this or does he not? Does he recognize that what prosecution is doing? And some of it, like Ann had said, is not prosecution's fault. They're waiting for like LE to hand in more stuff. And then, when they get it, nothing's in order. They got to, I'll let it keep playing here. I understand what's going on here.
Ms. Jennings about that. So it is no surprise to the prosecution that we do not believe a summer of 2024 trial is realistic in any way. Understanding the state's concerns, if a trial were to happen in Latah County, we would suggest looking at summer of 2025. However, council and the court's aware that our intention is to file a motion for change of venue. That hasn't been filed yet because we're not ready to have that heard yet. There's work that has to be done to present to the court and council in support of that. So that's just for the court's information. Your Honor, that in the state's scheduling order, it asks the court for various things. And a lot of those we don't have disagreement with. We think they're appropriate. And in fact, they were things that were covered by the court in the court's original scheduling order. As the court and council recalls, last fall, we had not made the choice to waive speedy trial. And so the court did a scheduling order at that time. It wasn't but a few days later that we'd had enough time to discuss that. And Mr. Koberger decided to waive his speedy trial, and the court vacated that order. So I'm familiar with what the court likes to put out there as far as a scheduling order, and I don't think there's a problem with that. I would want to inform the court that I do not believe this is a 6-week trial. I believe this is more like a 12 to 15-week trial. This is, as everybody said today, a very complicated case. And I want to talk a little bit about what drives both our request no sooner than summer of 2025. And I say that with fear, Your Honor. There are a lot of things that we have to still do. I want the court and council to know that we haven't sat around waiting for a scheduling conference to begin doing those things. We have been on this case and active and seeking discovery and reviewing discovery, meeting with experts and working the case since the day we were assigned this case. So with that said, there's still plenty to do. And I want to talk a little bit specifically about that. In a case where there is the potential for a death penalty, we're looking at 2 tracks of trial. We're looking at the innocence phase where there's tons of witnesses and a lot of things that happen. And if there is a guilty verdict, we immediately go to a sentencing phase. That's up to the jury what happens there, but both parties have to be ready to proceed forward. So we don't get the luxury of focusing on our case, the state's investigation, our own investigation solely. We focus on that. We are working on that, but we are required to begin our mitigation case. That's what it's called, the penalty case. We are to put on mitigation. We are guided by the ABA standards, American Bar Association standards in capital cases. That's what this is. A death penalty case is a capital case. and we're guided by those standards. And they tell us that as attorneys, we must investigate every aspect of the case in the innocence phase. We must meet with our client regularly, which we do. We must engage in experts.
I think I see where
understand
this is
issues that are
going.
pending, which we are. The American Bar Association guidelines in capital cases
Can
say
you see
we
it
must
coming?
hire a mitigator, and there must be a mitigation investigation. We hired a mitigator, probably one of the very first people we contacted. And so that has been ongoing for 13 months almost as well. We have not been sitting back and waiting. Your Honor, in this case, the complexities are that there are special areas of focus. And when we get to trial, counsel for the state will put on experts to educate the jury on specific areas of focus, as will we. And it takes a while to get all of that done. In addition to that, as court knows, everything is recorded. There's digital footprints all over the place. And so we have a lot of records that we have to go through. I know that the court has heard about 51 terabytes of information that we've received. And I want to tell you what that means. Ms. Massa found a statistic for me, and I want to tell you how much 51 terabytes of data is. And she found that. She was looking at Dropbox.com, and 51 terabytes of our discovery, to put it in perspective, 1 terabyte can hold 250,000 pictures. 1 terabyte, and we have 51 of those. Or 500 hours of high definition video, and we just have one of those. So 500 hours times 51, or 6.5 million document pages. And that's equal to 1,300 filing cabinets. And we have 51 terabytes, not just one. So that's a lot. There's specialized knowledge. There's a lot to go through in this case. We also have another player in the case, and that's the presence of the media. This is a case that has drawn a ton of attention from the media, and it continues to do so, and I don't think that's stopping anytime soon. The impact of that is that we have found that when we want to talk to witnesses, sometimes they don't want anything to do with us. Sometimes they're people that have already talked to the media too much, and so we shouldn't talk to them or bring them into the case. So that's just a complication. We're working through it. We're working around it. But that's something that the court has to be aware of. I want to let the court know that there are over 400 potential witnesses in the innocence phase alone. I personally and my team have talked to less than 10%, well less than 10% of those witnesses. In the mitigation phase, our mitigation expert has been actively working the case. We've all been working alongside our mitigation expert. There are still well over 100 people left to try to contact and try to interview. And let me back up and explain what we do with mitigation. We are to learn Brian's life story. We are to go all the way back to before he was born and learn his life story. We have to be prepared to talk about that in different ways. But it's not just a life story. We're required to go 3 generations back on each side, mom and dad. The court can imagine that there are a lot of documents that must be collected and examined and reviewed so that we are aware of things that we would need to present to our jury if we ever got to that phase. We have had a lot of trouble collecting documents. Sometimes it takes a court order to get documents. Sometimes documents are missing. Sometimes they're very old and you have to piece things together. We're working through it, but I want the court to know it takes some time for that as well. There are records yet to be obtained that we need in both sides. There are still experts yet to be hired that we need to find an expert that has the right expertise and will work on the case with us. We do have several, we're working with them, but there are still more that need to be found. And then let's come back to the discovery. I want to talk about some of the difficulties with discovery, and I want everybody to know that I am not disparaging the state when I say this. I'm describing a complication, a challenge, probably one that the state shares. In this case, we began asking for supplemental discovery in February of 2023. We had some initial discovery, and then we started looking at it and asking for other discovery. We are up to our 11th request for discovery, and there's, I think, 250 items total with subparts to that. The state will respond to us. They're not ignoring us. I'm not saying that at all. There's just a lot out there. But this is complicated because the discovery that we receive, the materials, there's videos, there's interviews, there's police reports, there's photographs, 13,000 photographs that come in, and they are not indexed. So you get a discovery file and there's tons of sub-files, and I believe this is the way the state's getting it too. And I believe this is complicated because we have multiple law enforcement entities that have been working on the case, and I believe they filter discovery through one of the entities and then it gets to the prosecutor. And I think they're hurrying as fast as they can to get the discovery to us. So I think they're giving it to us as they get it. But there's no indexing in it. So you must open each of those files and see what you have. And you might have police reports in sequence, and then you might not. And you might have photographs, but you don't know which officer took them. You can tell where they are, but you don't know which officer, and you don't know what day because the officers were in that residence multiple times. So that's complicated to try to match all of those things up. There are things that we've asked for that have taken, it's just taken a long time. The court knows we've had motions to compel, and we've had some pretty lively debates about what certain things that we should have and certain things that they don't want us to have for other reasons. Those things take time as well. We don't have complete discovery. I don't think the state has complete discovery, but we definitely don't have complete discovery. I'll give you a couple of examples. There is a video that's a really important video, and we early on received some of it, and we are still waiting for the complete of it. The court would know from our 11th discovery request that there's still outstanding portions of that video that we need to have, and I think the state's working through it, trying to match up video and sound together for the completion, the full several days worth of video. But there's not even an estimated day when we'll get that. And that is critical for us to review and hear all of that. So that's an example, Your Honor, that is not us.
Sometimes we hear things we don't want to hear, you know what I'm saying? And I know everybody wants this trial to start, but we have to look at it through Ann Taylor's and hopefully another lawyer soon. We have to look at it through their eyes and what they're seeing, and they're not getting the stuff in fast enough, the discovery in fast enough to be ready by 2024. And so Ann Taylor is saying, 2025 is what she's ultimately saying. That's the way I take this. And so I have a feeling that's what it's going to be, because there's just too much. I mean, 51 terabytes and stuff is still coming in. I mean, 9,000 fucking tips. Are you fucking serious? And that one really made me sit up a little bit, because I know they're not all against Bryan Kohberger. I think people are starting to talk. That's what I think. And I think there is another investigation. I think they're still investigating this. I really do. We have to have hope, right? We have to have hope. And we've talked about LE corruption, and, we've done shows on it. I would like to think that not all of them are, and that there's some out there that want to do a good job. And I mean, if there's tips still coming in, because they have not closed down the tip line, folks, they have not closed it down. So apparently they're not totally convinced of Bryan Kohberger's innocence either. I mean, him being guilty. I think there's some that that don't believe that. I don't know if you agree with me on that, but they are human, right? They are human. And if you take so many humans and you give them this information, what the information is against Brian Kohlberger, let's say that we did a poll amongst the LE. Of course, it's probably going to be higher that he's guilty, but I'll bet you money there's some in there that don't think he's guilty. And we have to have hope. We have to have some kind of hope that they're going to do the right thing. And sometimes, like I said, we don't want to hear what we hear, but I think what's going to happen, in my opinion, is this is going to go on until it's not even going to start until 2025. That's my opinion. I'll let it keep playing.
Saying we just don't want to go to trial, we just want to drag our feet. That is us saying there are critical things that we don't have. I am very concerned about expert reports. We have a draft of one, the CAST report. The court had ordered that we receive the CAST report. It's a draft. I don't think the state has it. I don't think they're sitting back on it, but I don't have that yet. And there are completed materials all over the place like that we just don't have. Our team speaks with the prosecution team fairly regularly about these issues. We communicate by text and by email about things like this that are coming up. We've sat down and spoken with them. They're very open to talking to us, but this just isn't a closed deal. There has to be a deadline on discovery. There has to be a target date where that ends. And then there has to be time to make sure that we've read every piece of it, watched all the videos, looked at all of the photographs, and know where they came from. A few months from now is not a sufficient amount of time to do that. There is no possible way I can even read or watch everything I have now or react to things that are still coming in if we're to have a deadline in time for a summer of 2024 trial. There is no possible way that I would be effective in my investigation, in my presentation to a jury, if I don't have the state's expert materials ready to give to my experts and then give them a report to respond to. There is no way that I am effective assistance counsel if I haven't looked at every bit of discovery that's available. Recently, Your Honor, as recently as January 4th, we received discovery that contained over 9,000 tips that law enforcement had obtained.
Jeff, I agree with that. I don't think, but they've pretty much, he was backed into a corner, and they had to drop the speedy trial. They were backed into a corner, and that was I think it was a very unprofessional, dirty move by the prosecution. And but now that the way things are looking, I think it's better for them to wait a while because they don't have all the information yet. They don't have all the information, and they just got 9,000 new tips. The tip line is still up. There's still an investigation going on. And nobody can tell me anything different. Otherwise, they would close that tip line down, which I expect them to do soon. Because it's actually delaying the trial. So what are they going to do with these tips is what I'm wondering. What is LE going to, because I guarantee you that not all of them are against Brian Kohlberger. I expect more than half of them to be like thinking somebody else is a suspect. This is a big crime community, and I know people are calling in tips from this channel. From this channel, and I can't even imagine what other channels are calling in. So, yeah, and we can't go backwards. Well, Jeff, you either get it or you don't get it. You either get it or you don't get it. They were pressured to drop the speedy trial. He should have had a speedy trial. They pretty much took that away from him. As a matter of fact, I can see this going to if he's found guilty, it will be appealed, and he will win an appeal. And that's what I think is going to happen. And I stated it before. They're going to find him guilty here. They're going to find him guilty. I see it coming, because they got to shine that fucking university up. They got to rub it and shine it and make it all nice and shiny. And that gets LE out of it. That shines back on the town again. Then it goes to appeal court, and and the right thing is done, and he walks free. That's what that's my opinion on what's going to happen. Of course, that's just an opinion.
And we've had this isn't a new issue. I think the court's heard about this before. We've had bits and pieces of tips, and they've come in and we've reviewed them. But the 9,000 new ones we received January 4th, those were closed out in October of 2023. And I don't think the state sat on them. I think that's an example of the process, that they close them out so they can give them to us, but they go through other agencies before they get them.
Hey Jeff, what's the lyrics to that Pink Floyd song? I got so many channels of shit on the TV. Do you know what line I'm talking about? You know what the line I'm talking about? Well, you know what? All you're talking about up there, the gas station employee and businesses and residents, maybe the reason for 51. You know what? That's 51 terabytes of fucking shit that they're making the fucking defense go through. It's probably a bunch of shit. That's my opinion. They don't have nothing. They don't have the license plate. They don't have nothing. And the defense knows this. That's why she can say so confidently that her client has no connections whatsoever to those people in that house. That's why she can say it so confidently. There we go. Anyway.
In the prosecutor's hands to give to us. I have to read every one of those 9,000 tips. There are things that matter to us in our innocence phase that have come up and been done, and I have to read them and appreciate them and react to them and see what's there. That's the duty I owe to Brian. That's his right for effective assistance of counsel, to have me do those things. Your Honor, summer of 2024, it's impossible for us to do it. Our team constantly meets, we constantly work. We are on this. This is our priority. Brian's our priority, but we are not going to be ready in June of 2024. Your Honor, I want to also talk about some of the other deadlines. One of the things in the state's motion for scheduling order had to do with the alibi defense. And as the court remembers, we had made some submissions and we needed more information before we could do anything more complete. We're still in that circumstance. But when the court vacated its scheduling order last fall, that was part of the scheduling order that was vacated. So the state asserts in its scheduling order that our time has expired, and that just can't be, because the court didn't carve that out and say, I'm going to vacate everything but this. So we'll need a new date, but I'd ask the court to be really mindful of the other information we need. We need the cast report. We need other information of things that past agents and other specialists with the FBI might have done with cell towers and records. And I don't have all of those yet. I have some. And the state has pointed me to places that they believe I have more that maybe I missed in the discovery, and I'll look at those. But I'm going to need some time to do that. I wanted to let the court know as well, because the court's going to be considering a scheduling deadline for 12B motions. I want us to have a clear picture before we have that deadline. And the clear picture that I'm concerned about is the state's pathway of how Brian Kohberger comes to their attention and is identified. I've read that PC affidavit over and over and over again, and I'm not sure. Over a year into this case and everything I've read, and I've spoken with our team, we're not sure how.
What she's asking
state
for,
decides on
by
things.
law,
I know
she's
different
entitled
places,
to everything
but
she's
I don't
asking
know where
for.
they fit together. And the more work I do, the less I know about how they fit together. And that is critical for us to assess 12B motions. So while the court's doing deadlines for discovery, I need the court to have something with the 12B keyed on when I have full discovery. I also think it would be appropriate for the court to allow windows to file additional motions based on later disclosed materials too. I think we'll just keep getting materials until the court sets a deadline for it to be cut off. Not anybody's fault, just the magnitude of the case. And so I think that would be something appropriate for the court to set as well. I think that covers it.
Thank you. One more question. So
Sure.
I understand this. I mean, I'm aware amount of disclosures already. But do we need a whole nother year after this summer? I mean, can I help everybody by having tighter deadlines to make things happen faster so that we can get this trial sooner?
That's a tough question. If the state says you have everything and I believe they could say I have everything they have, but I know there's other things out there. I know it based on responses to discovery. If I had absolutely everything, all their experts' reports, I would still need a period of time to read and understand that. There's not a shortcut for the amount of time that it takes to go through everything. There's just not a shortcut for that. Having a deadline for discovery helps me. It just does. Having a deadline for expert disclosures, that absolutely helps me as well.
To me, I'm going to stop this for a quick second. To me, and I've been saying this all along, and they're setting up for this. They're setting up for an appeal. And what I think what's going to happen is he's going to get found guilty, and that's going to clear the university and make it all shiny again. And you see what I'm saying? And law enforcement and Bill Thompson will get his win. And then it's going to go to appeal, and then Brian Kohberger is going to get caught, and it's going to be reversed, and he's going to walk. And that way, it takes it away from the county of Idaho and that city and everything. You see what I'm saying? That's where I think this is. I think this is what's going to happen in this case. My opinion.
Have the concerns of discovery that's not yet made available. I have the concerns of the time it takes to review all of the materials. And I have the concerns about the limitations we're finding with people being willing to talk to us, both for the innocence phase and the mitigation phase, should we ever get there. I have significant concerns. We're working on it. If you could say,
one trial, one time, so it doesn't come back. We can only predict the future so much, and we have so much power. So I'm relying on counsel So let's go to Mr. Thompson and see what you have to say about all this. Just getting things ready for trial.
Ms. Taylor is not understating the amount of work that's involved in this case, Judge. I think that's fair to say, and there's more information that continues to be developed. You know, it's kind of like you ask one question, you get an answer, and that leads you to another question. I know that
Jeff, you were saying about the 40 people, is that kind of, but the thing is, they're only interviewing the people. They're not going to go looking for people on their side. They're going by what they are handed in discovery. That's the people they need to interview. And if they're not getting the discovery, they're not being able to do those interviews. You see what I'm saying? I mean, they don't. You said back here, said where is this? Yeah, judging by many YouTube channels, it seems she'd find many to talk to on her side. Well, that's not what it's about, Jeff. That's not what it's about. It's about interviewing the people that they're saying is testimony against him, and the 40. Who's the 40 people? Well, it's the list. It's they're going by the discovery. That's what I'm trying to say. They're going by discovery. And if they've interviewed 40 people, it's something that's from the discovery. It's not that they're going on some wild goose chase interviewing people. They're just going by discovery.
Ms. Taylor and
Which hasn't been much.
counsel, and investigators are encountering that. We are trying to provide things as quickly as we can, and she's right. There are delays in with the multiple agencies getting everything together. The tips, for example, were part of a nationwide tip line that needed to be completely shut down before we could get all the tips that were in it. And so that's why it took so long with these 9,000. I didn't count them, but there are thousands and thousands of tips, most of which are out there. But you're right, most of all of which need to be looked at to see if they have any potential relevance to the case. As I indicated to the court, if we cannot have a trial this summer, then
how much you want to bet they're going to close the tip line down
next year, for the reasons that I've described to the court about the practicalities of carrying on a trial of that duration with the high school, with the universities. We need to be realistic about being sure that we can get our witnesses here. We'll have something to put them, and there won't be undue interruptions in the community that could cause issues with the community's perception of the trial proceedings. I'm not quite sure what else I can offer.
You're making some kind of argument that changing venue, but I know we're not arguing about that.
And, I don't think that's a changing thing, Judge. When this case has national, if not international attention. This spring, I was at Association of Council of Counties board meeting in McCall, and there was more news every morning from Boise on this case than we see up here. Every doggone morning. I have friends in this community who have traveled to Mexico, and they say, people here were from Moscow, and immediately they want to talk about this case. It's not Moscow, it's not Latah County, it's everywhere. So I don't think that a change of venue is going to solve any of these problems. And the state's position on venue is that the case should be held here. It's the Latah County case. We believe that we can select an appropriate panel of jurors from Latah County. We have the tools to work with that we've discussed with Your Honor. In fact, we already have a fairly comprehensive draft juror questionnaire to send out so that the court and counsel can assess the level of knowledge and the feelings of the potential jury pool But we think that we at least owe Latah County, the people of Latah County, the attempt to seat a jury here first. And not just rely on, there's been a lot of publicity. There's been a lot of publicity everywhere. The only place I've heard that there wasn't publicity is in Lewis County. Somebody was talking to a court down there and they happened to mention co-rotation, said, what are you talking about? So if we want to change venue, I guess we could go to Nez Perce.
Kind of small.
It's kind of small. Lodgings aren't very good as far as a lot of lodging. But I think that is a practical observation on this case. It's not just here. It's not just Moscow. It's not just Latah County.
Thank you, Mr. Thompson. So you're saying, you're looking at this realistically and the amount of information, evidence, non-evidence, that you might be looking at summer of 2025?
I'm saying that could be where we end up, Judge. I am still concerned about the victims and their families. I mean, they have suffered for well over a year now with a lot of uncertainty. And that's painful. It's an everyday reminder. And they need some certainty and they need some closure in a timely fashion. But we know we also have to make sure, as Your Honor just said a few minutes ago, that we only do this case once. That it doesn't come back on appeal, that it doesn't come back for subsequent things saying that somebody made a mistake. We want to do it right. And the factors are in front of Your Honor. I think that you're certainly in a good position to make the best decision.
It's a decision that pulls me in two different.
I appreciate that, Judge.
Yeah. I want to set it right now. I mean, I'd like to get a little closer with discovery and see if we can have that more quickly. I'd like to speed it up if it's possible. I'd really like to do this sooner than later. I mean, maybe March 2025, which Taylor, that would be a reach. I just want to let it percolate a little bit. I know everybody probably here, including counsel, want to direct a certain date. But when you're talking about a date so long in the future, potentially, maybe we can get to a point where we can move it more quickly. I'm not going to just let it hang for too long, but it's really hard for me right now to set something in 2025, even though that might be just the reality. And I know that there's lots of other issues to be addressed. I know there are going to be a lot of motions. Going to be a lot of motions about the death penalty as well.
I totally agree with that, best of me. And I've said that a few times, but you know what? I mean, we know it's never going to happen. We know that, and that's why I'm saying this is why I think sooner or later they're just going to pass a buck on and make this go to an appellate court, because that's the only way they can get out of this, by looking shiny clean. And that's my opinion, of course. I could be wrong. We'll have to see how this plays out. But yeah, I agree with you, best.
So it's realizing to think that we have to have a case so far in the future. But if that's what is the right thing for everything, to do it correctly. Maybe we only have to do it one time. Because we don't want to do this twice, we don't want to do this 3 times. Because no matter what happens, okay, if he's convicted, it's gonna be appeal. And that's also a challenge. So my heart goes out to the victims. I can't even imagine the pain, the grief, because you can't really go forward with your life without this hanging over your head. So, sorry. We'll see. All right, so I'm gonna contemplate a little bit. It's not like I have to set this within 2 or 3 months, apparently. And I want to do the right thing. Okay. So, does that conclude what we need to talk about today, Mr. Thompson?
Believe so, Judge.
Ms. Taylor?
Yes, sir.
Okay, well, thank you all. We are adjourned.
Okay, well, there it is. back to where we were, pretty much. Anyway, yeah, I have a feeling. I don't know if it has to go to 2025. It does. Think about it. Anne doesn't have all the stuff she needs. I have a feeling that there's going to be, at least one more lawyer coming on. That's my opinion. To help her. I think it's going to go to 2020, summer of 2025. That's my opinion. What's going to happen. So, anyway, I'm going to close this down, and I think I might come on later and rerun this one more time. But I want to see what I can find out, if we can find out anything about that 11 o'clock one. But I doubt it. But I got to try. Anyway, so I hope you guys got what was going on there and everything. And until next time, rock and roll.
song 5 years ago, hoping for peace in the north of Ireland, and things are looking better than ever. So let's hope for peace for Christmas.